All right. For the next speaker, I'd like to introduce Dr. Michael Vinluan, President-elect of the American College of Legal Medicine. Dr. Vinluan works as a medical legal consultant and consulting medical expert for various plaintiff and defense law firms throughout the U.S. He has provided consulting on complex multi-million-dollar litigation matters ranging from medical malpractice and medical liability, product liability to wrongful death cases, and has worked on some of the recent biggest multi-district litigation cases. He's the author of several textbook chapters on medical malpractice, product liability, and medical ethics, with a JD and a health law certificate from the University of Maryland Carey School of Law. His experience also includes pragmatic research and writing in emergent healthcare issues for policy development, both at hospital and national levels. His extensive dynamic background includes work experience at the CDC, FDA, and Johns Hopkins Hospital. He was the chair of the 2023 ACLM 63rd Annual Conference in Orlando, Florida, held in association with the University of Florida, Levine College of Law, and the Australasian College of Legal Medicine. Please welcome my friend and colleague, Dr. Vinluan.
Morning. Thank you, Tony, for that kind introduction. So we're going to talk about cannabinoid product liability and 2023 legal issues this morning for the next half hour or so. I have no financial relationship with entities that grow, produce, promote, market cannabinoids, THC, CBD, or marijuana. And this presentation represents my own views and does not necessarily represent the views of the American College of Legal Medicine. This is our outline today. We'll talk about first the basics of cannabinoids, definition of terms. We'll talk about some relevant legal issues, and then we'll talk about some basic facts about product liability. And as you know, we have a mix of attorneys, judges, medical doctors, nurses in the audience. So bear with me if some of the facts that I will present is a little bit quite basic for your field. For this presentation, I will not talk about the laws pertaining to prescribing medical marijuana. It's outside the scope of this presentation. State regulations on prescribing or recommending medical marijuana, as most of you know, varies by jurisdiction, so please consult your respective state licensing authority. Cannabinoids. Cannabinoids are a class of biologic compounds that bind to cannabinoid receptors in the central nervous system and certain peripheral nerve terminals, such as in the vascular epithelium. Cannabinoids are usually extracted from the Cannabis sativa plant. Again, as all of you know, of all the known cannabinoids, the most commonly encountered are the tetrahydrocannabinol, or THC, and the cannabidiol, or CBD. THC is the main psychoactive compound of marijuana. THC causes the euphoria or the high that people get from smoking marijuana. Now, in contrast, CBD doesn't cause that high, but it makes the user experience a feeling of well-being or comfort. Epidiolex is the first FDA-approved CBD prescription drug for the treatment of certain seizures. It's an oral solution taken twice daily. Let's talk about some recent legal issues surrounding the use of cannabinoids. So in 2018, the Agricultural Improvement Act, or the 2018 Farm Bill, facilitated the wide-scale cultivation of low THC product by removing hemp from the definition of marijuana in the Controlled Substances Act. So it removed hemp from the CSA. Hemp, as most of you know, is a variety of the cannabis sativa plant. It's used to make ropes, clothes, and food. Hemp has less than 0.3% THC. Thus, hemp-derived CBD is legal in the US. Again, hemp is used to make ropes, clothes, food, etc. The 2018 Farm Bill explicitly preserved FDA's authority to regulate products containing cannabis or cannabis-derived compounds. Question: is it legal for dietary supplements or foods to contain THC or CBD in the US? FDA has determined that products containing THC or CBD cannot be sold legally as dietary supplements. Food to which THC or CBD has been added cannot be sold in interstate commerce. Now, whether they can be sold legally within a state depends on the state laws, as many of you know. According to the FDA has concluded that a new regulatory pathway for CBD is needed that balances individuals' desire for access to CBD products with the regulatory oversight needed to manage risk. The agency is prepared to work with Congress on this matter. The FDA's existing foods and dietary supplement authorities provide only limited tools for managing many risks associated with CBD products. Again, according to the FDA, given the available evidence, it is not apparent how CBD products could meet safety standards for dietary supplements or food additives. For example, that means FDA, have not found adequate evidence to determine how much CBD can be consumed and for how long before causing harm. Therefore, the FDA, do not intend to pursue rulemaking allowing the use of CBD in dietary supplements or conventional foods. So currently, as of October 2023, FDA's position is that CBD products may not be sold as a dietary supplement. I think I have an error here. Yeah. There is a current bill in Congress called the Hemp and Hemp-Derived CBD Consumer Protection and Market Stabilization Act of 2023. This bill allows the use of hemp, cannabidiol derived from hemp, or any other ingredient derived from hemp in a dietary supplement, provided that the supplement meets the other applicable requirements. The 2022 Medical Marijuana and Cannabidiol Research Expansion Act. It became law in December 2022. It is a federal policy that removed many barriers to cannabis research, and it facilitates trials and development of new FDA-approved drugs that use marijuana or CBD. Since 2018, FDA has approved four that I can find, cannabinoid products as safe and effective. One, as I mentioned earlier, is the Epidiolex. it contains a pure CBD for the treatment of certain seizures. Second, Marinol and Syndros contain a synthetic THC for treatment of anorexia associated with weight loss in AIDS patients, also for the treatment of nausea and vomiting associated with cancer chemotherapy. The fourth drug is Sesamet. It has a chemical structure similar to THC. It's for the treatment of nausea and vomiting, again associated with cancer chemotherapy. Now let's have a quick overview of product liability for attorneys who work on product liability cases. This is a little bit too basic for you. Please bear with me. So what is product liability? Product liability is a legal doctrine in civil law that gives consumers a right to file suit against a manufacturer who sold a defective product for injuries suffered as a result of the foreseeable use of that product. So the key terms here are defective product and foreseeable use of that product. In product liability law, a product is considered defective when its design, manufacturing process, or warning instructions renders the product unreasonably dangerous to consumers. Design defect. A product has a design defect if the product has an inherent and unreasonably dangerous design, meaning from the beginning, the product was designed with an inherent design defect. Compared to a manufacturing defect may have been designed well and safe, but the finished product departed from its intended design. So you might recall certain lot numbers being recalled for contamination during the manufacturing process. So that's an example of a manufacturing defect. Failure to warn. This is based on the manufacturer's failure to provide consumers adequate warning of risk or dangers of using the product at issue, thus rendering the product in essence defective. Which product can be subject to product liability lawsuits? Any product sold in the marketplace or placed in what we call the stream of commerce can be a subject of product liability lawsuit. Who can be sued in a product liability suit? Any entity responsible for putting the product at issue in the marketplace can be named as defendants in a product liability suit, including, of course, the manufacturer, but also distributors, retailers, pharmacies, trade associations that promoted the product, and in medical product cases, the prescribers and users of the product, like the surgeons. Now, product liability is based on several theories of liability. So, plaintiff attorneys, itemize these theories of liabilities in their complaints. Typically, they try to include all of these in the complaint. Negligence, strict liability, breach of implied warranty, breach of express warranty, misrepresentation, and fraud. Other causes of actions related to product liability include violation of consumer protection laws and deceptive trade practices laws. Negligence. Negligence occurs when a person or entity fails to exercise reasonable prudence or care. That's the basic definition of negligence. Torts 101, negligence is failure to exercise reasonable care or prudence. Like a four leg of a chair or a table, negligence needs four elements to stand in court. One, a legal duty owed by the defendant to the plaintiff. Two, breach of that duty. Three, causation, or what we call the but for the action or omission of the defendant, the plaintiff would not have been injured. And five, the resulting damages. These are the past and future medical expenses, loss of income, pain and suffering. Next is strict liability. Here, the plaintiff must prove, again, here, the burden of proof is on the plaintiff. The plaintiff will need to prove his or her case. The defendant typically does not need to prove anything, but just to say or show the jury that the plaintiff failed to prove his or her case. In strict liability, the plaintiff must prove that the defendant manufactured or sold the product, that the product was defective when it left the defendant's possession, and then the defect caused harm to the plaintiff. So, unlike in negligence cause of action, in strict liability, the plaintiff does not need to prove any wrongdoing on the part of the defendant manufacturer. As long as the product is defective, then strict liability can be proven. Breach of implied warranty of merchantability. This cause of action or theory arises when the manufacturer sells a product that is not generally fit for the purpose of which similar products are normally used. Breach of implied warranty of fitness for a particular purpose. This arises when the manufacturer sells a product that is not fit for the product's specific purpose. Breach of express warranty. This is based on a guarantee made by the seller that is relied on by the buyer in the form of TV ads, product labels, or statements given during the sale or after the sale of the product. Misrepresentation and fraud. This occurs when a defendant negligently presented relevant facts that are not true about the product and that these facts were relied upon by the plaintiff. That's misrepresentation. Fraud, in many cases, is a type of misrepresentation where the defendant knowingly or intentionally or even recklessly provided a material statement that is false to induce the plaintiff to use the product. Just like any other lawsuits, defenses are available for the defendant. In product liability cases, these are the most common defenses raised by the defendants. One, assumptions of risk. You assume the risk by using the product. Two, product misuse, meaning they use the product not as intended or not as directed by the instructions. State of the art, it's a complex legal issue, but it simply means that during the time when the product was manufactured, it is the only available science or technology. Therefore, you cannot hold them liable for any knowledge or technology that was acquired years after the product was manufactured. Statute of limitation and statute of repose. These are deadlines to file a claim. Federal preemption. Again, this is a very complex legal issue. Basically, it's where federal law displaces state law due to the supremacy clause of the US Constitution. It's a complex issue because defendants want to oftentimes argue that, hey, the FDA approved it, so why are you suing me based on state law? Something like that. Now, the next one applies to the clinicians in our audience. It's the learned intermediary doctrine. Here, the medical doctor prescriber or the surgeon, for example, who used the medical device is ultimately held liable in court for injuries of the patient because the medical doctor is the one who knows the specific patient that was injured, so long as the manufacturer gave the doctor, for example, the product label or instructions or information about the product. Here's the product label. Use it as you deem proper. If you get sued, you're on your own. Alternative causation, I typically review medical records for pharmaceutical companies who are sued because of their product. And one of my objective is to find some alternative causation that the product did not cause the injury, but the patient has a family history of cancer, smoked for 30 years, things like that, family history, risk factors. These are easy defenses for product liability cases. Basic, mass tort. Mass tort are civil actions involving numerous plaintiffs versus a defendant, like a product manufacturer. So a lot of my friend doctors ask me, what's an MDL, what's a class action? Basically, multi-district litigations or MDLs are cases in one federal court, one judge. Cases are heard by one judge, but the cases are still tried separately, individually. They do that for efficiency purposes so that both sides can present their cases to one judge and not to multiple judges because, the allegations typically are the same. Whereas in class actions, one or more plaintiffs represent a group of plaintiffs, sometimes hundreds, sometimes thousands, under the same cause of action. So there is a group of plaintiffs that represent collectively by a member or members of that group, and any outcome affects the entire group. So going back to cannabidiol, what are foreseeable causes of actions against manufacturers and distributors of cannabis products? Design defect, again, design, not designed. Edible cannabis product might contain dangerously high concentrations of THC. That's a design defect. Manufacturing defect, a certain batch of the product deviated from the product's specified THC quantity. Failure to warn, a manufacturer failed to warn of certain risk or adverse effects associated with its cannabis products. Let's look at one real case law. Snyder v. Green Roads of Florida, LLC, case in 2020. Plaintiff Snyder, a citizen of Florida, purchased a 250 milligram version of the defendant's CBD oil through the defendant's website for a total purchase price of $43. Plaintiff Terry, a citizen of another state, Ohio, purchased a relax box through the defendant's website for a total of $104. The relax box contained CBD gummies, CBD tea, and CBD oil. Each plaintiff claims that he relied on the product labels in making his decision to purchase the product, that the product labels misrepresented the amount of CBD that each product contained, and that as a result, each of the plaintiffs was overcharged for the product used or product they purchased. The complaint alleges in a federal subject matter jurisdiction based on a federal law, so they filed it in federal court. It's based on the Class Action Fairness Act of 2005. Count one, unjust enrichment by both plaintiffs on behalf of a nationwide class of all purchasers of all of the defendant's products sold throughout the U.S. within the applicable statute of limitations. Count two, by Snyder on behalf of the Florida subclass of all Florida purchasers of all the defendant's products for a violation of the Florida Deceptive and Unfair Trade Practices Act. So what did the court say? The court opined, plaintiffs do not have standing to assert claims based on the marketing of the products that they did not purchase. Remember, there are hundreds of other plaintiffs in the class. And therefore, the classes described in the complaint are overbroad. The court further stated, plaintiffs simply have not alleged a likelihood of future injury. Why? Because in their complaint, they made it clear that they will not purchase more of the defendant's products so long as the labeling does not meet their standards. Accordingly, plaintiffs lack standing to assert a claim for injunctive relief because they will not buy the product again. Regulatory oversight, and this goes back to our previous slides about the FDA. The court said that the regulatory oversight of CBD ingestible products, including labeling of the product, is currently a subject of rulemaking at the FDA. The FDA recently has concluded a public hearing and instituted an agency task force on CBD regulation. Right now, there's still no rule. They're still trying to create a rule. So how does this lack of FDA rule affect the issue? So a lack of formal FDA rule or regulation governing cannabis products can be a defense of manufacturers against product liability claims. A manufacturer of cannabis product can request and be granted a court stay in a product liability suit pending administrative determination of issues within the agency, in this case, within the FDA. So it's like putting the issue, pausing the issue. So it's a short presentation, but I'd like to thank you for your attention. Again, I'd like to thank Dr. Sandy Sandor for inviting me in this presentation today. Thank you.